Bringing Morris Mbondenyi, the Dean School of Law at the African Nazarene University, and I'll ask you the first question Linda asked the president of the ASP. What does that ruling, the adopting that, amending Rule 134 of the Rules of Procedure and Evidence, mean for the cases against Uhuru Kenyatta and Ruto legally?
Well, Ben, when you look at that particular amendment, you would actually see the sense where the Assembly of State Parties is actually coming up with a new playing ground, whereby if somebody has official status, then they will be immune to attending all the court proceedings. I think that is the implication, first and foremost, of Rule 134 and the amendment thereto. But when you read the rule deeply, and when you consider the implications, then in light of the ICC statute, you'd find that the rule now brings in more implications, which will be subject then to the interpretation of the ICC court. I want to point a very important point here. What the Assembly of State Parties is actually is equivalent to Parliament of a country. So the Assemblies of State Parties is just the political wing of the entire ICC mechanism. But whatever they pass shall actually be subject to interpretation by the court, the ICC itself.
Are there any dangers of anybody in Kenya going to court to challenge that particular decision?
Well, locally, there is no such a possibility because the ICC is actually a separate mechanism from the local mechanisms. The only thing that comes in is now the rule of complementarity, where, of course, there must be some complementarity between the national jurisdiction and the international jurisdiction. So somebody cannot actually go to the Kenyan courts, and challenge the decision of the Assemblies of State Parties. But in future, somebody could actually, and I guess the prosecution could actually, at some point, challenge that rule within the chambers of the ICC.
What does that ruling mean politically for Ruto and Uhuru?
Politically, that gives them the room and leeway to be able to attend to their constitutional obligation. We know very well that they have got a lot to do since they are duly elected the president and the deputy president of the Republic of Kenya. So that gives them the leeway. You can remember that it was a little bit difficult for His Excellency William Ruto to shuttle between The Hague and Nairobi. Perhaps now this amendment to the rule gives him now the leeway to be able to attend to matters in a better way from Kenya than from the two countries.
Yes, now the case against William Ruto and Joshua Arap Sang is enjoined. The Rome Statute says that there should be no disparity when dealing with matters at the ICC. What does this leave Joshua Arap Sang?
You see, Ben, to be honest, that is where I fault the amendment that was imposed by the Assembly of State Parties, the Article 134 amendment. When you read that amendment in conjunction with Article 27 of the ICC statute, you'll find a disparity. Article 27 is categorical that one's official status does not bar them or grant them immunity from prosecution. And you'll find Article 27, Sub-Article 2, going further to say that the court will not have regard to any form of immunity, whether it is substantive immunity or procedural immunity. Article 134, according to my own interpretation, now brings in what we call limited procedural immunity, whereby an accused person would not really have to attend to court sessions in full. Not only that, when you read that article and you read Article 63 of the Rome Statute, Article 63 sub-Article 1 is categorical that an accused person shall attend court in person.
Yeah.
And that is very clear. An accused person shall attend court in person. What Article 134 is purporting to do is to vary Article 63 of the Rome Statute.
Yes.
And Article 51 of the Rome Statute is categorical that where there is a conflict between the rules of procedure and the Rome Statute, then it is the statute of the provisions of the statute that would prevail.
Yes. Finally, Dean, very quickly, Kenya is still pushing for full immunity against for President Uhuru Kenyatta and for the sitting heads of government and state and their deputies. How do you see this going?
Well, it actually calls for the complete understanding of international politics. I think the mood at the moment among most of the big brothers, so to speak, of international justice is to the effect that ICC is there to prosecute and, if possible, punish those who are most responsible for atrocity crimes, the crimes that are clearly stipulated in the ICC and the Rome Statute. The intention is to punish those who are most responsible. And when the ICC mechanism was being put in place, people knew from the onset that those who are most responsible for atrocity crimes are either heads of state or people who hold key positions within a state or within the state machinery. So it would be ironical now for ICC, the Assembly of State Parties, to allow such an amendment, knowing very well that the mechanism was put in place to be able to deal with matters that cannot be effectively dealt with at the national level. So to me, I see really on that we may hit a snag.
Thank you, Dean. Always a pleasure.
Thanks a lot. Thanks a lot.
Morris Mbondenyi, the Dean, Faculty of Law at the African Nazarene University.